Oops. Okay, ladies and gentlemen, sorry for the little delay. Like everybody else in eastern Massachusetts, I've spent the morning trying to figure out how to get rid of ice dams on my house. Before we get started on the order of business, there is a sign-up sheet out front for anybody who is here that wants to speak about any of the horse racing issues. So if you, even if you have been invited to speak, even if you've already submitted paperwork, anybody that wants to speak, please be sure to go out and sign up outside so we know about it. We're trying to figure out how long it's going to take today. Janice is out there at the front desk. With that, we will go to the first item of business, which is usually the approval of minutes. This time we're going to postpone that because we don't have a quorum of people who were here last time. I wasn't at the last meeting, and Commissioners McHugh and Zuniga are on vacation today, so we will postpone the adoption of those minutes. We will then go to item number 3, Administration, Executive Director Day.
Good morning, Chairman Crosby,
Commissioners.
Good morning.
I just have a couple brief comments here for a general update. One is that I would like to start just a little increased public information around the need for businesses and vendors and really employees and parties that expect to be participating as Penn opens for business in June, as we understand. And just to remind everybody that the licensing and registration process does take some time, which means that about right now you should have at least your completed, and I stress the completed part, your completed application in to the Commission and be prepared for processing. So those of you that have not at this point but anticipate you're going to want to, you need to get a call into licensing, talk with them, and by the way, the number is 617-978-8400, and make sure that you're going to be prepared when you expect to do business for Penn.
So this is both vendors and employees, are you talking about?
Correct.
Okay.
It has a lot to do with the key employees or the employees that Penn needs to have on duty as they begin opening, because those key employees take a lot longer to complete a background and complete the investigation than just a normal employee. And vendors in particular, if people are either anticipating or if Penn is anticipating people doing business with them, they need to get their completed paperwork in.
Have you spoken with Mike and Elaine about putting that up on our website and sending it out to everybody we know and all that?
Yes, Mr. Chair. As a matter of fact, Elaine will be following, and a team will be following up with public information to expand on that. We have a brochure to have that material ready as well.
Great. Okay. Terrific. Very exciting that we're starting to hire people and lots of people and get lots of suppliers going out there.
I think the snow we think it's a long ways away because of the snow, but it's actually getting pretty close.
It's only 4 months, right? Was it March, April, May, June? 4 months. Wow. Wow. Great. Okay.
The second item I had, I'd like to draw your attention to item 3A, and those may be familiar. Yesterday, about 184 letters went out to Suffolk workers to let them know. It's both a letter from Chairman Crosby, of course, and from WIN's president, to let everybody know that they're aware of the licensing condition and their commitment to preference for qualified Suffolk employees. And it's the intent of this letter is to be able to put those folks that be interested in touch with WIN representatives. So the idea is once somebody gets that information, if they take a look at it, if they are interested, that they send in a card, prepaid postcard to WIN to indicate that interest in a job or that interest in employment with WIN in the future, and they are even looking at jobs today.
Yeah, this is really important. I just want to mention this again. One of the conditions, I think it was, that you other commissioners put on the WIN license, right? So when the other 4 commissioners made the decision to select WIN, they made as a condition of the license that Lynn would offer a preference to anybody from Suffolk Downs who lost their job and would like an opportunity to work at the WIN facility. So we have now worked with the folks at Suffolk Downs to get the names and addresses of all those employees, and we've sent a notice out to all those employees that included a letter from Bob DeSalvio from WIN offering an opportunity to talk to WIN to all those employees if they want jobs, and that's a really great thing, and WIN has taken the commitment seriously. It was terrific.
Yeah, Mr. Chair, they actually made the offer before it went in as part of the condition to
They
the
did.
license. But
Okay.
they made that initial offer.
Great, okay.
And Chairman Crosby, I might note as well that and the letter acknowledges this, is that, of course, we are still talking about the possibilities for thoroughbred horse racing to continue
Right.
in Massachusetts, so it recognizes that discussion's going on, but wanted to err in the favor of employees that may be looking for other opportunities to make sure they have the early availability to do that.
Right, well said. Great, thank you.
If I might then, I'll move on to topic B. And
Yep.
you've seen these letters quite often lately, so last meeting you might recall that our team and GTEC, we kind of, the commission, well not kind of, but the commission selected GTEC to provide CMS services in Massachusetts for the commission. The selection, of course, had a number of conditions. I'll hit on those briefly. But since our last meeting, our team, together with GTEC, have been working on a final contract. And for a number of reasons, including the complexity of the contract, but I think also having a lot to do with our various weather cancellations and inability to continue to meet while that's been going on. For those reasons, we made substantial progress on such a contract, but we haven't completed the contract negotiations in its entirety. Well, what we are hoping that we can, the Commission would be interested in or would allow us to do is really grant us the authority to complete negotiations and sign a contract with GTEC for CMS services, provided the final contract includes directions from today, any changes that might be there, and the addendum that we'll discuss here in just a few minutes, proposed by staff with no material differences. So we're basically asking, if we have the direction book, can we go forward and make sure that the contract, those directions are included in the contract, and if we successfully do that, sign the contract, and seeking that authorization for the commission if you would be willing to do that. With that, just a quick couple of comments on the addendum that's in your packet. Should be 3B. We believe that the addendum that you see there does reflect the discussions and the conditions that the commissioners applied as you voted to approve, or not approve, to select GTEC pending contract negotiations to provide CMS services. I identify kind of 4 key areas. The conflict of interest, which was a lot of discussion, and the solution to that was proposed by IAB with a series of policies. Those policies have all been listed in the addendum with the concept that upon signing the contract, they would have 30 days to submit and have those policies approved. Also, along with that section, there was a condition about early termination options that would allow the commission, really in 2 cases, if we were able to develop a system. And the other one would be if we were going to select to assume operations, that we could opt out of the contract. That is still in its infancy, but we have a skeletal idea, I think, of what that might look like. And then pricing options, there's a lot of discussion from the Commission on the concept of being able to defer, really, some of the cost of the contract to later years, and when the revenues would actually be coming in. And then the last of those was actually sort of a combined thing, was what I call a warranty. And the idea of that section really is that you heard a lot about 3 different kinds of communication protocols, but what it comes down to is that the CMS that went in place would be able to select information without jeopardizing the operation of those floors in any combination that the licensee would end up putting on the floor. And as well, what this contract or what this addendum includes is an addendum that would impose damages if there for some reason was some problem. So it says, yes, we can do that, and we understand we need to do that, and B, there's damages in there if that didn't take place. The specific pricing options and the early termination options, I want to defer to Derek because I think he's prepared to go ahead and discuss those with the commission. And maybe when that takes place, then John may have some additional technical comments to to give a little more detail than I provided. So if we can go to Derek now, I'd appreciate it.
Good morning, Commissioners.
Good morning.
Just a few pieces. Rick did an excellent job of summarizing where we've been to date. I want to thank the GTEC team. I want to thank Council Blue and Council Grossman for their assistance on this. I want to thank the IEB for their input. So it's been a lot of people pulled together with a lot of snow in between and some travel. Under the policy piece, once again, we have put down 30 days, but this is a collaborative effort. Our team has to work with GTEC to come up with these policies, make sure that they meet our approval, so it's going to take some substantial effort on our side. I don't want you to think it's all just on the GTEC side. On the opt-out, we did receive information today. I know that was of interest to a few of the commissioners. What GTEC has given to us is basically a verbal of, and they've worked the number down from what their initial number was. Was it to be $12 million for an opt-out, reduced by $100,000 for every month going forward, but that could change based on whatever scheme we pick on the pricing. So I'll let GTEC talk about that opt-out later. Now, we just did get that number, so I'd like to negotiate that number a little further with GTEC because I don't have all of the financing behind it and the understanding behind it. So I'd like, if you approve at this point, some ability to negotiate that point a little further. And then comes the pricing. What you see on this chart are five different scenarios. You have our initial contract offer, which was 180, and we didn't put in the one-time costs onto this grid or the refresh because those don't change. So we just took the variable costs. So what you see is the base cost of $187.7 a month. What we had asked GTEC to go and do was take a look at years 1 through 3, see if we could change that a little bit to 1, help our licensees who don't have revenue coming in during that time period, and 2, help to offset the appearance of a negative return on investment, even though it would be a positive return on investment over the whole life of the contract. For those 3 years, it was a negative return on investment. So what GTEC has done is come back with 4 different scenarios. The first 2 take a 66% reduction to the contract price over the first 2 years, with payback options that go up higher in years 4 and 5 and then level out a little bit more in 6 through 10. And the second 2 scenarios are 50% reduction with higher paybacks in years 4 and 5 and leveling out years 6 and 10. If you ask me my opinion from a personally financial perspective, I'd say take the initial offer, but that isn't what we came to negotiate. Because with each one of these is somewhat of an increased cost because GTEC is losing money in those first few years, so they have to borrow, and then there's a cost to borrowing. So if you ask my opinion and we had to go with one of these options, I'd go with option D. I think it takes into consideration, 1, what our licensees were asking for, a leeway during the first few years. It doesn't increase the contract price to a point where it puts GTEC as not the lowest bidder at that point. And it also pays back the amount of revenue that's borrowed in years 4 and 5, which is when our licensees should be receiving their maximum amount of revenue. So when I'm talking about WIN and MGM, that's when they're anticipated to be opening up. They'd have higher revenues, most likely those first 2 years, than just because it's what our consultants have told us is that's when everyone wants it. The demand is the most. And then it levels us off back to the contract base price.
That's D as in David.
D as in David, the last option on the chart.
Questions, issues?
No, I had a chance to discuss this chart thoroughly with CFAO Lennon, and so I think I understand it, and certainly we're going to defer to his expertise on this financial matter. It makes sense. Your argument makes sense.
Thank you.
Question?
I also had a chance to review the pricing options with him. I agree with his analysis that option D could work the best for both us and obviously for our licensees who are helping us foot the bill.
Have you had, this was a clause that came up, I think the commissioners brought it up, right? That
Yes.
was one of our concerns,
Correct.
was that the front loading of the costs, and that was a concern expressed on behalf, presumably, of the operators, right? Because we didn't want to, the licensees, we didn't want to burden them with heavy cash flow pressure at a time when there were minimal cash flow. A, and B, we didn't want to appear to be looking like the most expensive system in the world for a relatively modest-sized operation, both of which made sense, and we agreed on that. But have you had any opportunity to ask the operators, the licensees, whether they like this scenario too? I don't know whether they spoke up or not, or whether we sort of superimposed our judgment anticipating what they would be concerned about. Do you have any feedback from them?
I have not had any feedback. I haven't asked for it, to be frank. If you want to narrow it down to two options, the first or the second, the initial offer or the second one, I can bring that back to them, and that could be our final contract price.
Well, it's not totally dispositive. There were other reasons why the commissioners brought this up, but this ultimately is the operator's money, and these are monthly fees, right?
Correct.
Monthly payments. So
With the cost below it, subtotals for the years.
right.
And
So
then added out to,
you're picking up, something like $3 million in positive cash flow over 3 years at a cost of $1.6 million. If I were an operator who, in the big picture, didn't have cash problems, I just had bottom line problems, not problems, but issues, I don't know that I'd make that trade-off. I just don't know. I mean, I think you could argue it either way. But I think it would be worth getting their feedback on this, and just factoring that into your calculations. As far as I'm concerned, I totally agree with the other commissioners that you guys have really studied this hard. You've responded to the issues that have been raised. G-Tech has been patient and responsive. I'm more than happy to delegate to you the final authority to negotiate the deal. But since it is ultimately their money, it does seem like it's worth at least asking them, whether they have any particular preference one way or the other. I suppose that raises the question, if the operators came back to us and said, we don't really live in a world where we're worried about our cash flow, we worried more about our bottom line, and we would just as soon go with the original proposal. If that were said, again, I have no idea what they're thinking here. They may not look at it this way at all. I don't know. But if they did, would you all be comfortable going back to the original proposal, or do we feel strongly that we want it to be one of the scenarios, the other scenarios, as selected by Derek and Rick?
Well, I thought the main reason was to accommodate. I understand the perception issue as well.
Yeah.
But I thought the main reason, are we correct in saying that, was to
There was-
accommodate?
there were serious concerns about cash flow without
Yes.
revenue coming in.
So those were expressed to you?
Correct,
Okay,
By the
so this-
operators?
correct.
By the
Okay.
licensees. So this is not trying to think about what they're thinking. This is actual conversations with you.
Correct.
Okay, okay, good.
But
Okay.
there was the return on investment issue that came up too. That was a strong conversation. If you remember, we came up with a chart, and
Yes,
So
that
for the
was,
first 3 years.
Commissioner Zuniga
Yeah.
felt strongly about that, so I don't want to speak for him.
Right. And it just depends on how they all look at it. If they're managing on a system-by-system basis, then this is going to be helpful. If they're really managed from the big picture, their overall corporate financing, I don't know that this matters or not at all.
Correct.
But, so why don't you just,
well,
reach
yeah.
out on that and
Okay.
and those of you who are here already you can give us your thoughts on that. Beyond that, I'm completely in agreement to vote to approve delegating the decision-making and the rest of the negotiating to you all.
Yeah, I think that termination number is very high, and I know you have not had a chance to negotiate that piece yet, but I know you are an able negotiator, so I would be comfortable approving, giving you the authority to continue and finalize this.
And just one final disclaimer, there are a few clauses in there that GTEC has not signed off on. One of them was, we're still negotiating the terms of, so I think what you see in there is my ideal scenario of the terms of a liability payback if anything were to go wrong. And I think GTEC has come with a fair negotiation, fair starting point for that term for negotiations too, so we'll probably meet somewhere in the middle. But they have not signed off on that one. And we put it in there just because that's my ideal scenario. Would that be accurate?
Yeah, it's still something that we're.
Use the mic.
Yes, it's still something that we're talking about internally, and it wasn't something that was included in our pricing, so we'll have to continue discussing that item.
Okay.
Were there any other concerns with any of the clauses in the addendum?
The only other point, obviously, and this is the point that I overexpressed at a previous meeting, but there is the concern about, we do have a deadline here. We're trying to get up and running, and so, at some
Correct.
point, we need to just get going and not so squeeze the production cycle that we're having to compromise terribly in order to get up and running on time.
And I think we have the backbone of a good deal, so we're not going to let anything really,
Okay,
a small point,
right,
hold this up on our end.
okay.
So Derek, just for clarification, in the addendum, the portion of the document that's in red, those are your proposals?
Yes, those are the pieces
Those are
we
your
had come back with,
recommendations?
yeah.
I just had one question, it just kind of leaps out at me, is are we clear on the central monitoring system having the capacity to support up to 20,000 electric gaming devices? Is there any difference between that number, what we might realistically expect to have in terms of the cost of the system?
No, so the way it's explained to me is whether it's 1,000 or 20,000, it's pretty much the same.
Okay.
Same capacity, same pricing.
Okay.
Okay,
And then did GTEC have anything else?
Just one other small point, and I was talking to Todd Grossman about this earlier this morning. I think we would just like to see a little bit of stronger language around the conflict of interest issue and GTEC's ability, or its affiliates' ability, to sell electronic gaming machines into the licensed facilities. But I think that we're in a place where we can come to an agreement on how that language would work.
Okay.
you're on with that. Where you going? Okay, great. Commissioner Cameron, do you want to frame a motion?
So I move that we authorize our staff to continue and finalize negotiations with GTEC in order to begin implementing the central monitoring system.
Along the broad parameters in the
Yeah,
paperwork.
as we mentioned earlier, taking into consideration our comments today and previous comments which are articulated in the addendum.
Second?
Second.
Any further discussion? All in favor?
Aye.
Opposed? The ayes have it, 3-0.
Thank you, Commissioners.
Thank you all. Thank you, GTEC. Okay, we now come to item number 4, Legal Division. General Counsel Blue. Okay, great. General Counsel Blue.
Good morning, Commissioners.
Good morning.
Good morning.
I wanted to suggest that maybe we do item 4B first because it's very quick, and then we can have our speakers come up.
Yep.
And so I have Attorney Holmes here to ask you for approval and describe what we're asking you to approve.
So, in your packet, you have
Pull that over a little bit more.
the draft of the Section 14 regs for supplemental licensing procedures. Because they're racing regulations, they need to be submitted to the legislature before they can be fully approved and enacted. So we're just looking for a vote from from you guys to allow us to submit them to the legislature.
And the gist of them is, the intent, the purpose here?
For the supplemental licensing?
Yeah.
They were procedures that governed our, the new policies that we had kind of enacted for the one-day license and the supplemental licensing that followed for this particular situation that we're in racing.
So am I right? Basically, what this is doing is codifying the kind of informal agreement we made to do everything we could to accommodate partial, part temporary, one day, et cetera,
Right, it put the
placeholders.
procedure in the regulations. We've already passed them by emergency.
Right,
And we're going through the formal process.
okay. Great. Any questions, comments? Do you need a motion,
Yes.
Commissioner?
So I move that we adopt the supplemental procedures for licensing pursuant to 128A, and that is 1401.
Second?
Second.
Any further discussion? All in favor?
Aye.
Opposed? The ayes have it unanimously. You're right, that was quick.
Thank you.
Thank you.
In your package today, you have a lot of material on various racing issues. And just to explain so that the general public knows what we're doing today, we received between last October, November, when you approved a number of one-day licenses, through the end of 2014, a number of letters requesting various actions by the commission. And we thought that it would probably be best for the commission to get a full picture of what is going on with racing in 2015, and to have the stakeholders come in and present to you in person what their thoughts are, and to explain some of the requests that were made. So we asked the stakeholders to come in. We asked those who wish to submit briefs or letters on some of those issues to do that, and you have those letters in your packet as well. We've had a number of folks come in and sign up to speak in person. And really what we would like to do is understand what their concerns are, what their plans are for 2015, and to give the commission the opportunity to ask questions. So I think, Chairman Crosby, you have the list of folks who are here. They
Right.
can come up in, any order that you would like, and
Okay. And just for the commissioners to know, we have representatives from the two tracks, Chip Tuttle and Lance George, who are here to answer questions, but they're not necessarily asking to speak, but feel free to ask questions of them if we want. Okay, we'll just go by the order on the sign-up sheet. Martin Corey, I believe, is first, from the Horsemen's Association.
You submitted a letter?
Yeah, and help us find your letter first before we start, before you start.
It's near the back.
What is the date of your course?
February 11th, Mr. Chairman.
Okay,
it should be in the second section of your packet. It's under the racing briefs section, I believe.
Yeah.
Second section?
There's, I think you have two sections in the packet that Amy put together. Yes, there's a
Was
section
this
called,
from, is this from Ed Nowak?
No, it's right after that,
After that?
or before, just before that, I believe.
Yes, Martin Corey. Got it. February 11th, it's the next to last letter.
yep, page 61 of 74.
Got it?
You can start.
Okay, welcome. Introduce yourself.
Thank you, Mr. Chairman, Commissioners. I'm Marty Corey, appearing today on behalf of the Harness Horsemen's Association of New England, and have sent in a letter for your packet for consideration on issues related to the harness horsemen and the Racehorse Development Fund. Specifically, without reading the letter, the primary focus of my remarks relates to the allocation of the Horse Race Development Fund. We would like to ask the Commission to refer back to the Horse Racing Committee the allocation and the consideration between the standardbred and thoroughbred, based specifically on the request for racing days. when the initial consideration and allocation between the two groups was made, it was based on racing days being equivalent. And under the two proposals that I've seen, the suggestion by the thoroughbreds is a request for somewhere between 25 and 50 racing days. And we think that that's such a material change in circumstances that before any consideration can or should be given to what the fund will be used to, what the thoroughbreds will be able to spend the money on that they get from the fund, that a rejiggering of the fund should be considered by the racing committee, and any adjustments that are felt equity would require would be done first before there's any subsequent conversation.
Questions or issues?
Well, I'm a member of the racing committee, so I'm very well aware of the work that was done, and you are correct when you say that the initial premise of the work was done on 2 full racing seasons. I don't know if, did we have a chance to look at this letter from a legal standpoint? And I know that the decision has lays out all the statutory pieces. I think that would be important for us to look at. The only other issue pending is a couple of spots on the committee that have to be filled. So I know that we're working on doing that. I know the requests have been made to the appointing authorities to fill those positions on the committee. So at this time, the committee is, there is a quorum, but it is not a full committee at this time. But I find this to be a reasonable request.
Could I ask a question about this? And I have not followed this anywhere near closely, obviously, as Commissioner Cameron has. I take at face value what both of you say, that it's sort of presumed 2 full racing slates. But everybody knew that there was no guarantee that there was going to be either a harness track with a license or a thoroughbred track. So although I gather that it was sort of presumed for the sake of the discussion that there would be equity, it had to be, everybody was aware of the fact that anything could happen. There was no guarantee that Suffolk Downs was going to end up with, excuse me, let me just finish on this. And I remember discussion as we were sort of working our way through this, and as I heard the Racehorse Development Fund folks talking about, that one of the issues that was anticipated about the possibility of this money was that if a track went dark because it didn't get a license, that there would be the possibility of accumulating funds which would eventually induce the development of substantial purses, and thus the economic model that might bring back harness, or not, whichever racing didn't occur. And I remember talking about other markets with Jennifer and Dr. Durenberger and others, where we heard about markets that had gone dark and where pools of money had been built up to induce development. So was that not part of the sort of understanding that this was part of the background noise as these decisions were being made?
Our position, Mr. Chairman, would be that under Chapter 23K, the number of racing days is specifically stated, and that would supersede the conversations that you're talking about.
So you're saying that somehow or other 23K says that the committee's decision has to be based on?
No, there's a reference to an equivalent number of racing days between.
And that's somehow tied as
into the
premise?
Considerations of the 5 principles for the split or the allocation
right.
of the Horse Racing Development Fund.
It sounds, it's a consideration, but it's not defining. It's not dispositive. It doesn't assert that something must therefore follow. It's just one of the factors that they're asked to consider is the number of racing days.
I would agree.
I mean, that makes perfectly good sense to consider. I mean, totally makes good sense, but there was all this other stuff going on and other possibilities that we were all aware of. What that exactly means about the split, I personally don't have an idea yet, and I don't know what the racing committee would think, but I just want to make sure that we have an accurate memory of sort of the way the ground was laid here as we reconsider this, if we do.
We would argue, though, that the significant difference between a 25 or 50-day meet versus a 100-day meet, that was not part of the equation
Right.
when the allocations were made, and that fundamental fairness would require that that issue be reopened.
Right.
And-
Well, I totally agree with Commissioner Cameron that what you're saying is a perfectly reasonable point. You know, the idea of having the committee rethink this under the circumstances makes sense. But I also think that it is a perfectly plausible outcome of that reconsideration might have been that what we want in the long run is a lot of racing days down the road in both sides, and let's figure out a strategy that will most induce the development of the long-term health of the industry. And that may or may not mean altering the formulas. I don't know. It's a different lay of the land.
Fair enough.
Other thoughts?
Yeah, my thought was just that it's a reasonable request for the
reopen.
committee to reopen.
I totally agree with that.
Certainly with no feeling at all about the outcome until all the issues, including a legal analysis, would be discussed by the committee members.
I completely agree with that.
Thank you very much.
All right, thank you. Next up is a familiar face, Mr. Carney. Mr. Carney and Mr. Carney.
One time or another around here.
Good morning.
Good morning. Nice to see you, Commissioner. The reason I was anxious to speak today is the Brockton Agricultural Society and the Middleborough Agricultural Society are two companies that I'm involved with. And back when there was a question about racing, whether harness racing or horse racing, thoroughbred was going to continue, I got involved at the fair and had meetings whereby if Suffolk Downs wasn't going to run, that I had to make the property available to conduct parimutuel thoroughbred racing at Brockton. Back about 8 or 10 years ago, I spent about $3 million renovating the place, and if it was to start over today, it would probably cost me $5 million. But anyway, so much for that. But my position was that this would give the horsemen an opportunity to run. I had meetings with both sides as far as the thing was concerned, and I also met with the breeders. George Brown is sitting behind me. I've known him for many, many years, as well as I met with the legislative agent for the HPBA, the thoroughbred representative on Beacon Hill, and we had many discussions. I also met with the president of the HPBA, and as far as the thing is concerned, it was a question of maybe it would all depended on what Suffolk was going to do, and I made it very clear from the start that I wasn't in a race to compete against Suffolk Downs. If they were going to run, that was one thing. If they weren't, it was another thing. I'd make the property available. And we had lengthy conversations, and it was one of those things that was kind of a fallback position for the HPBA. As now, as time goes on, that things change. In my life, when one door opens, another one closes. Since we got started, I have now been involved with the possibility of the Brockton Agriculture Society, the Brockton Fair, where I get tied up with Rush Street Gaming or Mass Entertainment, technically whatever way you want to describe it. But there's a possibility that Brockton may become a casino, which I'm very hopeful will happen, but that's one, I always live on hope. So I just want to say that as far as the thing is concerned, if we can, it wouldn't interfere with the construction of what I hope might happen, that the fairgrounds property would be available. It would help either side, or just the breeders, whatever it was, as long as it didn't compete with what Suffolk Downs had on the table. I have a good relationship with Suffolk. I've been working for them together with Chip Tuttle for many years. And I understand that it's always, today with things always up in the air with not knowing quite what direction to go in. I don't think anybody has a clear-cut answer to what will happen, only hopefully that the purses will be so great when the casinos get going that it should attract top-flight horse racing. as far as the thing is concerned. And the only thing is this, that I'm an old horse racing man myself for many, many years. I started with the horses, and I learned a lot about it. And I just want to say that as far as the fairs are concerned, the applications are both on hold as far as the thing is concerned. But I would just want to leave them in a safe place so that things fall apart, and if it's possible, that we could run at Brockton this year here on whatever would help, but our location would be available. And that's about all I say. If there's any questions, I'd be happy to answer them if I can, as far as the thing is concerned. But most of the people here know me. I've been dealing with them for many, many years. So I just want to make it clear. I don't really want to withdraw the applications unless I have to, because there's always a chance if they can't work it out. I'm hoping it won't be for a long-term solution, because I have now gone in a different direction. But I just wanted the commission to know what our position was, that if we could be helpful to keep it going, I would be happy to do it, as far as the thing is concerned. If you have any questions, if I can answer them, I'd be happy to, sir.
Mr. Carney, so I think what I'm hearing is because there is uncertainty about racing at Suffolk Downs, that it makes it impossible for you to move forward with any kind of a plan, because you have clearly stated that your facility would be available if there was no racing at Suffolk. Is that accurate?
That's more or less, that I didn't want to have people think I'm putting an application to compete against Suffolk Downs, because I've been working with Suffolk Downs for many years and have a great working relationship with Chip Tuttle, that's sitting here today. But if it was one of those things, if they made their mind up they weren't going to operate, that as far as Brockton was concerned, would make it available. But since then, my own situation has changed quite a bit since then, because now we have an application before the commission for a full-blown casino at Brockton. And if Suffolk decided they were going to shut down permanently, that if this coming year, that if it wouldn't interfere with the construction, hopefully, just say hopefully, something might happen, that would make the property available for a year or two till they could find another place to find a home or get together and, find another location where they would go. But I would be very happy to work with the horsemen, because I know most of my life, and my son Christopher's also been involved with most of them. So that's about what I'd like to say.
I haven't had the chance to go out and visit the track in Brockton, and you talked about some of the investment that you made a few years back. What, if anything, would you need to do to the track to have it prepared?
The
for
track,
racing
it
season this year?
would, with the type of business that we're involved with, because we're in the construction business. If you went to the Brockton Fair today, you'd think you're in Alaska. I think I got more snow there than I have in Alaska, because it's been shipped in out of the city and from every place around, because it's such a huge facility. And anyway, that we put new barns in, and we renovated the grandstand. We have a very good, we had a tote system. We put a rail from California there with I forget now what they call it, but it was one of those safety rails. It would probably cost me, maybe by our cost, probably around $300,000, and we'd be up and running. Because we kept the place up even though we weren't using it. We've had my son had a lot of horses there of his own, but he had probably 20, maybe 30 or 40 of them up there. George Brown, I think, has a few of them down in his farm right now. But anyway, it's something that we could swing into, get it going on even if it was for a short meet, I'd be happy to do it. And I told George Brown about the breeders. I met with their lobbyists and people who represent them. That I know that if it was for a short meet, maybe the breeders, I spoke with them also, as well as the HPBA. There's two factions, not two factions, but there's two operations.
Okay, thank you.
Anybody else? All right. Thank you, gentlemen.
Okay,
Thank you.
Thank you.
There are, I think, two representatives from NEHBPA, Mr. Rafidi and Mr. Three. That's fine. A, B, and C. Anthony, you're never C. If you're, we have quite a few letters from you, so if you'll guide us to as you approach a topic, let us know which one you're talking about.
Thank you, Mr. Chairman. I'm Frank Frizzoli, and I'm General Counsel to the NEHPBA, and I'm also a member of the HRC Committee with Commissioner Cameron. And before we address the issues that the HPBA has raised in, I think, 9 letters to the Commission, I would like to respond to the comments of Mr. Corey of the Harness Association and the deliberations of the HRC that result in a recommendation that was ultimately accepted and implemented. As the Chair correctly noted, at the time the HRC first convened, Suffolk Downs, the thoroughbred industry had run, I think, approximately 60 days the last 2 years. And the statutory condition had been for 100 days for an extended period of time, and it had then been reduced to 60 days at the request of the thoroughbred industry because of the scarcity of funds available for purses. And the objective of the statute, I think, was clear, to look at the long-term picture and advance both the harness and thoroughbred industries. And to that end, the HRC engaged the services of an outside consultant, Dr. Margaret Ray, to prepare a report relative to the allocation and look at the different factors. And I might comment, ironically, I think I was the only dissenting vote in retaining her services. But in any event, her report came back, and it clearly stated that it was the thoroughbred industry that drove the economic engine in Massachusetts. And her recommendation initially was that more than 90% of the funds be allocated to the thoroughbreds. And ultimately, in her final report, I think she was in the 85% range in her recommendation. And notwithstanding that, the vote of the committee was 75-25. So we hire an expert, we get her recommendations, and the recommendations were not accepted. Significantly less of the fund was allocated to the thoroughbred industry. And I would suggest that the reason that that happened is precisely the present situation which the harness industry seeks to revisit. And I would suggest that any revisiting of this is quite premature. Mr. Raffetto, who is with me, is going to address the issue of the prospects of racing for the next 2 years, and I'm pleased to say that I think you're going to hear that we thought we had an agreement. We hit a last-minute snag, but I think we're about to reach a conceptual agreement which will have thoroughbred racing for 2015 and 16 at Suffolk Downs. But I will defer to Mr. Raffetto on that issue. But the point I'm making is that until the year is cleared to see what the thoroughbred industry is going to do, it is clearly premature to refer this matter back to the HRC, if it should be referred back at all. So I would respectfully request that the issue be tabled for another week or two to see what happens with the agreement we think we're about to reach with Suffolk Downs. And I would also comment that in any event, I think the chairman's comments were appropriate, that at the time this allocation was made, I think everybody in the committee understood that we had only raced 60 days the last few years, and we weren't likely to race more than 60 days. And I suspect that we will race somewhere around 50 days the next 2 years, not a big difference. So I don't think it's appropriate to refer the matter back, but it's not an issue I think you ought to address today or at this time.
Can I just clarify an issue, Mr. Frizzoli? The legislature allowed both industries to race 80 days rather than 100 days the last couple of years. You're saying 60 days, it's 80 days the last couple of years.
Chairman, Commissioner Cameron, we did not race 80 days last year.
Well, that was because of the licensing issue, and they made the decision to shorten.
I think the real reason was because of economics, as Mr. Frizzoli has said, purse revenue. Well, I'm explaining to you what happened. I don't know what, in principle, everybody thinks, but what happened was we didn't have adequate money to run extra days. And in addition to that, everybody knows this is not a secret, the horse population isn't what it used to be. So because of safety issues, and I like to brag about the actual safety issues we have at Suffolk Downs, we probably have the best safety record in the entire country and have had the last 2 years. And that is because of the fact that the kudos to our trainers and the way they maintain their horses. They ran as frequently as we feel were acceptable, and our purse allocations would not allow us to run any farther. And just for thought, what has been one of the biggest snags this year is that the revenue that is available from the racehorse fund, the money from licensing, and the money that will be generated at Plainridge when they start generating revenue, that is our biggest problem with a meet, because we do not have adequate money to pay purses for 50 days, and we do not have adequate revenue to lease the facility so it can be cost-wise feasible for the ownership at Suffolk Downs to make the business decision to allow us to do that. That is our biggest problem right now. We are short $3 million, using 100% of all the licensing fees and all the anticipated revenue based on the figures that we have received from everybody involved in this whole new operation about what should be generated from the slots. And that is starting the revenue flow in July, a month early. And everything I'm telling you.
No, I'm just commenting on the fact that the legislature allowed from 100 days to 80 days. And
Well,
then there were some issues around horse safety. I agree.
It was
But-
altered because of money.
Yeah, okay.
Good, Frank.
So I will move on to
Okay.
the next issue. And we had provided a series of letters, and let me deal with them perhaps by the date and caption. And we had a letter dated January 26 to the attention of Danielle Holmes regarding economic assistance pursuant to Mass General Laws 128A 5H4.
Got it? I do.
What's the date on that one?
January 26th, it was the first one you and I talked about last night.
Yeah, where is it in
The
the
20
packet?
grand.
Yeah.
It's about halfway in.
Okay, so on that particular issue, and I picked this because this is short, the HPBA has traditionally been funded with funds based on a contract with Suffolk Downs. And what would happen is that under our contract, there would be a pool of funds available from racing that would come from simulcasting, from payment of the premiums, from the ADW money from places like Twin Spires, which is Churchill Downs, ExpressBet and TVG. They would pay rights fees, and we would traditionally share this pool of revenue with Suffolk Downs in some fashion. In the last few years, it's been basically a 50-50 split of net revenue, where one half of that revenue was paid into purses at Suffolk Downs. And in addition, under the contract, Suffolk Downs would provide funding for the HPBA out of that revenue too. So traditionally, the funds that are so-called purse funds have been used to support the HPBA's administrative expenses, its welfare programs. We have a pension fund. We have a fund that provides insurance for the trainers that is subsidized in large part by the HPBA. So we would have contractual payments beginning in January each year where Suffolk Downs would be paying some money according to set schedules. And under the contract we have with Suffolk Downs, there would be installments, and those payments were in addition to the so-called purse payments referenced in that contract. Well, the HPBA has had severe cash flow issues, and so we understand that there is some money available under Chapter 128A, and we have asked the Gaming Commission to have that released to us. Suffolk Downs is in arrears on some of the payments due under 2014. We've had amicable discussions with them. We expect that to be worked out shortly. But you know what? We don't have the money. And we have the pension payments that we need to make. We have the medical payments for our trainers that need to be made. And we're basically looking for money to keep our organization going. In addition, as you'll hear from us, we have retained counsel to advance legislation which is about to be filed to develop a new entity to actually purchase a location and build a thoroughbred racetrack, be funded by bonds, and we have a business model to follow that the utility companies have used in the past. We expect that there will be good support for this. So the long-range plan for the thoroughbred industry has been to get to a position where we're self-sufficient, where we control the venue at which we operate, where we build something that is a 2016 model track as opposed to the facilities like Suffolk Downs, which were built, a century ago. And the sport has changed radically. Today,
Let's just keep to the point.
Okay,
So the
point in this is simply, we're asking this commission to release whatever funds might be available to us.
Okay. Let me just clarify, if I remember correctly, you've talked about three different sources of funds. One is disputed revenues with Suffolk Downs. As far as I know, at the moment, we have nothing to do with that issue.
That's correct, and I'm not going to ask you to address that today.
The second one is, I think in this January 26th letter, 128A, Section 5H4, which is the $20,000 request.
That's correct.
That's what you're talking about?
That's what I'm talking about
Okay.
now, and I'm seeking we have those funds released to the HPBA as soon as possible.
Okay.
I know that legal has taken a look at this matter. I know that those funds are typically for individuals from both, from.
It is.
So I'm just asking you if you've had a chance to take a look at this and your thoughts as far as a legal analysis here.
So we did review this. This is a fund that is provided with $20,000 every year. That's the maximum amount of money that goes in. We take requests from either occupational licensees or people who work at the track on the backside who've had some economic disruption or an injury, and we try to provide some kind of assistance to as many folks as possible under that fund. It has been our policy to limit those funds to about $2,500 per claim so that we can spread them out. We also ask for proof of need, so we also, we get from people copies of medical bills, copies of food bills, heating things. I mean, that's what we've used it for predominantly. We have not used it for an organization to fund their expenses, but really to help individuals who are in dire need.
Is there, does one of you have in front of you the language that actually says what this money is for?
We can pull it up.
All
It
right.
does say that it's for people at the track, occupational. It talks about those groups of people, and they have to have an economic need, usually medical or some
If
kind
I
of
remember, that language
economic-
is somewhat
Yes.
specific.
It is, and the kind of proof that we ask is very specific as well.
Well, go ahead.
Well, if the language is specific, it sounds like I guess what I'm asking for is a recommendation based on the legal, and I guess we want to pull it up first before you can do that, but it just, those requests will continue to come in, correct?
Yes, they do. They come in often. Okay. So what the statute said is $20,000 annually to the commission, which is authorized and directed to establish rules and regulations for the purpose of using these monies to provide economic assistance to any person employed in the racing facility, the stable, or the backstretch area of the horse racing licensee located in Suffolk County, who is facing hardship due to illness or unforeseen tragedy.
Okay. Other?
Well, I mean, I think it's important. We've used that money. I know many of the cases in which we've offered assistance, or rather the fund is there for that reason. I'm just not sure, Mr. Frisoli, maybe you can speak to the fact that this is not an individual, that you're asking as an organization, and secondly, to deplete that fund for those individuals as we continue to get those requests. Had you thought about that, sir?
I would suggest that it is the discretion of the commission to decide how best to use those funds, and I would note that the NEHPBA represents a lot of people in the industry, and that the use of the funds, the reason we seek to apply these funds is to sustain the benefit programs, the medical insurance we pay for the trainers, and the pension payments we pay. We don't have funds available at this time.
Do we use it up every year? Does the 20,000 get used up every year?
I believe it does.
And that's both tracks, correct?
This is just for Suffolk.
Just for Suffolk.
The 20,000 is?
Yes, but we oftentimes get claims for people who haven't gotten a full 2,500, but who have sustained injuries over a number of years. They have ongoing injuries and ongoing needs. So it's not necessarily just what happens in a season that 20,000 goes to, but it can go to people who have been injured or suffered something in prior seasons as well.
Yeah,
Well,
okay.
I come to this looking, trying to figure out a way to find a pool of money that can be used in an extraordinary circumstance. But this doesn't seem to me to be a clear-cut case of giving us the opportunity to do that. If anything, it might be a little more clear-cut on the other side. And I wouldn't want to, personally, I wouldn't want to move on this. We have proven ourselves quite flexible in our ability to try to find the language or find interpretations of language in our law, in our regs, to get us to do what we think are appropriate public policy initiatives. But that would, in this case, I wouldn't want to do that without the other two commissioners here. I think even though it's small money, it would be a decision. I would really want to know their feelings, their thoughts about this, and I'd like to get a little bit more fleshed out, at least see the whole language, so I really knew exactly what it was trying to say. I hate to say let's put a decision off for two weeks, but I personally wouldn't want to move on this without the other commissioners.
We have no objection to tabling this.
Can I ask for clarification? What happened to the fund in 2014?
Are you asking whether it was used in
Yes.
2014?
Yes,
I believe it was, yes.
it was. I thought, all right, I
Yeah.
thought we were talking about, I was misinformed. I thought we were talking about money that was there from 14 that hadn't been used.
No, I know we've gotten,
I don't think there was an excess in the fund.
Okay,
I'm
that's
I'm
all.
not
I think
sure,
we've-
but
Let's
I've
do,
Yeah, I mean, we
seen them.
could check and
let's
see.
do double check. That's
Yeah,
one of
we
the
should
things.
check it.
Please,
In the last,
please.
because you're using the words I think and I believe, and let's make sure on that.
Why don't we do just maybe a small spreadsheet with, articulating where those monies, the requests that we did grant? That
Thank
might
you.
be helpful to you as well,
Yes.
Mr. Spadia?
On a related issue, another request for funding, you have a letter of January 7, 2015, addressed to Dr. Durenberger. Regarding economic
Which date was that?
January 7, 2015, regarding to Dr. Durenberger, economic assistance pursuant to Mass General Laws 128A, 5H4.
Hang on a sec.
You may not have that letter in your package because we were advised that the larger letter superseded the prior letter for this same economic assistance. There
Okay.
were two letters sent to us on
So
this
what's the most-
topic.
what's the more-
February
Let me-
11th?
Can I just address the issue? I can do that briefly.
Well, if it's in our packet, I will have reviewed it and had notes, and I just want to make sure. So what's the more recent version?
The one that's in your packet that has
Okay.
the attachments and the tables on the economic assistance.
Okay. So this is about the Racehorse Development Fund.
I
Is that right?
believe,
Is that-
are you discussing the same economic assistance fund under 5H?
What we addressed in this letter is that there is simulcasting revenue that's coming in to Suffolk Downs since the first of the year. And under the statute, Suffolk was required to negotiate with the HPBA and pay at least a minimum of 4% of that revenue to the HPBA. And there, I believe, is other revenue that's available at this time from gaming that's in the general purse fund.
It's under the
And-
Racehorse Development Fund.
From the Racehorse Development.
Okay.
Yes. And with respect to the simulcasting revenue, my understanding is that Suffolk Downs' position is that whatever money is to be paid under the statute, the minimum under the statute, that they were seeking some approval from the Gaming Commission before that they would pay that to us. And I would suggest that the statute provides that they are to negotiate and pay us, and I would seek a vote from this board that the board has no objection to them honoring the, making the payment directly to us as provided by the statute.
Is this one, sorry, is this one that you've,
So this, I believe, what we're discussing is referred to in a February 11th letter to me, and it says request enforcement of licensee's obligation to pay 2015 simulcasting.
sorry, just stick with us here.
And that's the 11th? of the-
It's February 11th, yes, and it would be addressed to me.
Request enforcement, okay, got it. Right. Okay, so have you thought about this one?
So we have, so ordinarily, monies earned, let's take 2014, for example. Monies earned in 2014 would have been paid by Suffolk Downs pursuant to their contract with the Horsemen. Suffolk Downs has not asked us for any sort of approval for 2050, and as we know, they got the ability to simulcast while being dark for the first quarter of 2015. They have not, discussed with us how they're paying those premiums or what they're going to do with that. As I understand, the Horsemen's position is that there is no agreement between the Horsemen and Suffolk Downs for 2015. And it is the Horsemen's position that since that is the case, their 2014 agreement with Suffolk Downs governs. And
That's the section that's quoted here, right?
Yes, and that could very well be correct, but I would submit that that is a matter between the Horsemen and Suffolk Downs, and if they come back to us with some concern that they want to raise before the commission, we could certainly consider it, but right now I think it's an issue that they should be working out together.
Where do you get the idea that we have some role here to enforce this?
I don't get the idea that the Gaming Commission has any interest in this. Suffolk has said that the premiums that the money they're collecting now from simulcasting, they propose to pay it as the commission may direct. And
Okay, so maybe we should hear from Mr.
Mr.
Tuttle on this issue.
After, or should we do that now, or?
Well, we're doing it one by one.
Yeah,
Can we-
let's wait. We got a few more issues with this, don't we?
But I'd like to get them resolved.
One by
Yeah.
one?
One by one, rather than come
Mr.
back.
Tuttle, would you think he's
If I
willing to
may
speak to
comment.
us?
Sure.
I'm Louis Raffetto, President of New England Horsemen's Agriculture and Racing Corporation, and also advisor to New England HPPA. Understanding that this document was sent in as we were negotiating, and I can get into that in greater detail, but I think that hopefully as we move forward, this might just become a moot point. So I really just, and I understand.
Okay, well, if that's the case, then we'll let it go. I mean, you two guys, make up your minds. You want us to do
Right, no,
something on
well,
this or not?
understanding that Mr. Frisoli just going through the documents because it was sent in prior.
But he just asked us to move on this issue.
Right, well, again, the whole negotiation has been in a state of flux, and at this point in time, we would prefer,
So you're asking us to table this issue?
correct.
Okay.
Okay, it's tabled.
And now I would
That was
like to
easy.
defer to Mr. Raffetto on the issue of the 2015 racing season plans. And the letter that addressed this was dated February 11, 2015, addressed to Catherine Blue, and it says, regarding 2015 racing season plans.
Okay, hang on just one sec. Is this the one, comment on Sterling Suffolk Race Course request for race days in 2015?
No.
No?
No, it says regarding 2015 racing season plans.
Do we
It's
have
right
that one?
It's right
Yeah,
after that one.
It's the one
It just
after
says
that. It's just
2015 racing
before the
season
Penn
plan.
National letter.
Yeah,
Yep.
right after the one we just had.
Okay. You got it?
I do.
Okay, we are good to go.
Okay. Thank you,
Mr.
Mr. Chairman,
Raffetto.
fellow commissioners. Again, my name is Lou Raffetto, and I'm here as an advisor to the New England HPPA. First of all, I wanted to just point out there's been a great deal of effort made by both sides in recent weeks and most recently over this past weekend to try to bring a deal to fruition. And understanding that the horsemen really weren't holding a lot of cards in this game, I think it's very important to publicly thank Suffolk Downs for their Suffolk Downs ownership for their willingness to continue discussions, and also more specifically Mr. Tuttle, because he made a huge effort to try to again bring this to fruition. We had some communications earlier. Chip, and he can get up here now and speak for himself, but he thought we were in good shape and they were papering a document. But understanding this executory agreement is contingent upon legislation, passing that permits simulcasting for Suffolk Downs for the next 2 years based on some number of yet-to-be-determined days, between 1 and 50, and also usage of the racehorse development funds for administrative and operational purposes. I think it's important to understand, and believe me, I would not be here if this was just a matter of keeping the patient, or in this case, the industry, on life support just for the sake of having it on life support. As as was pointed out, there's a long-term plan here. While it's important to think about the jobs that are involved, to think about the local economy that's affected, and the agriculture, the farms that are impacted negatively by the loss of racing, this is really more about 2017, and that's the light at the end of the tunnel. Again, as Mr. Rizzoli pointed out, we're looking for the funding, the long-term funding here that would enable us to acquire a piece of land, build a boutique racetrack that would hold some 4,000 to 5,000 people, which is what most venues really need in this day and age, and create a first-class racing venue that would make sense. Basically, we need the legislature, as I say, to support this, that would allow the simulcasting to occur, to continue for the next 2 years, and subsequently, we need the approval of this commission to allow the funding, assuming it would pass, and to determine how those funds would be utilized. Moreover, as Mr. Rizzoli pointed out, we're going to be introducing a co-op bill in the coming days, and the purpose of this bill would be to raise revenue, a bond issue that would be guaranteed by the gaming funds. And essentially that would ensure the long-term viability of thoroughbred racing in New England. So that's where we are right now. I mean, as far as it relates to the situation with Suffolk Downs, again, I think I'll give kudos to their team for working so hard with us. And I'd be glad to answer any questions that I can. And then, of course, Mr. Tuttle can come up and say a few words for himself.
So you're not asking us to, I think what you're saying is you feel like you're close to an arrangement, an agreement, and so it's a little premature to really talk about specifics, right?
Well, this is true. I mean, we're very, very close. The specifics, as I say, are really going to be determined to a great extent by this commission. It's extremely important for a variety of reasons. number one, we need to get the legislature to pass the bill, and the timeline is extremely important. If we're going to move forward and race this year, and let's just say we'll take the maximum number of 50 days, there are a couple things that need to happen. One, we need to have access to the funds, and in their entirety over the course of the season, in order to pay the lease
When you
payments.
say the funds, you're talking about the racehorse
Development funds, and also other revenue that comes from ADW, simulcasting,
Right,
and live
okay.
racing. The other part that's extremely important, that I think a lot of people can lose sight of sometimes, again, is the timeline. And it's the legislature moving on this in a fashion, and in subsequently, hopefully, if it's passed, that this gaming commission would also move quickly, because if we're to run a meet that would be 50 days in length, beginning, let's say, theoretically, Belmont weekend, we need to notify horsemen. We need to know who's coming back. We need to know how many horses are coming back. And that really has to be, we need to know that no later than the end of March. We can't go ahead and say,
Right.
well, we think we're going to do this. Are you coming back?
But I think, following up on what Commissioner Cameron said, so relative to these issues, including the big one, which is the Racehorse Development Fund monies, it sounds like what you all are saying is the landscape is gelling. It's not quite gelled yet. Therefore, we don't have the data to act, whether we want to refer this to the HRC or not, whether we want to, anybody wants to reconsider the splits or not. We don't know what the thoroughbred part of the equation is now, and that if we sit tight for another week or two, chances are you will be able to give us the facts that we can use to make these decisions.
Yes, Mr. Chairman, that is correct. I mean, I think the point here is to really allow everyone to understand that we have come to a meeting of the minds, at least we believe we have. As I say, it's just an executory agreement at this point in time. There is nothing for this commission to do at this point. It's just extremely important that everyone understands the issues, and the issues, it begins with the legislature passing this swiftly, and then hopefully, if that is the case, and there's enabling legislation, that subsequently this commission moves likewise.
Right.
If I can just say, you're giving us your timeline, and that's important, and I understand you've been working hard toward this, but we also have things that we need to do that take time. Background investigations. If you're forming a new company, that investigation has to take place before we can act. We need time to research requests to use funds differently than they've been used in the past. So my suggestion would be that you start on that background investigation immediately. It's my understanding that those conversations with Lieutenant Connors have not happened yet.
They have not. There was a misunderstanding along those lines.
Secondly, working with legal is essential, because we can't act, we can't move forward without a legal analysis of what your request is. So the sooner you can get that information to us, the sooner we'll be able to move forward.
We understand that.
And I agree completely, and we do have certain procedural and process periods of time that we will insist on taking. There are two sides to every story. So it would be very helpful if you guys could work out a sort of a critical path chart principally with legal, maybe with Attorney Holmes, so you and we know what are the critical path items between now and the time that you all think is your go, no-go, or your drop-dead date, and tee us up as best you can to be prepared to try to work with those timelines while also giving everybody else a fair chance to participate.
We would be delighted to do that.
Okay.
In all due respect, Commissioner Cameron, I think this might clarify a few things. Over the past 20 years, so everybody gets a true handle on what our real problem is, and I live with it day to day, more specifically than my two partners here this morning. And what I mean by that is that the big problem right now for my husband and my farmers and my breeders is that the HBPA in past times has always had the opportunity to get a percentage of revenue from per se the purse pool to operate the HBPA so that we can pay, as was said previously, our employees and our medical benefits. And what I want to be very clear about is that we can't pay them. So there will be people losing their medical insurance, losing their life insurance in the next month. So what I want to be clear about is, and I have said it in a number of letters to legal, the Racehorse Development Fund, when it was designed, and with the fortitude of the legislature and the Gaming Commission to provide that source of revenue, so we would have a lifeline, as you may call it, did not think that if we cannot use the way purse accounts have been used for 20 years to support the backbone of our people so that we can live day to day, we cannot exist. So specifically, if the Racehorse Development Fund or committee would kindly realize that the definition of purses should always be that those purses should be able to be used to allow the racing entity that's running at that meet at that time in that county the fortitude to use those revenues to run the business. And they can be audited, and they are audited.
The issue here is, what is thoroughbred racing going to look like so we can make an intelligent decision about how to handle the Racehorse Development Fund? And your passion right now is, well, let's hold that until you have made a decision. You can tell us what thoroughbred racing is going to look like. And once you do that, then
What happens in the meantime to the people that need medical insurance? What happens in the meantime to the life insurance for the trainers?
but you're not asking us to do anything between now and the meantime. You've asked us to
No,
table
I sent a letter, Mr. Chairman, and asked to change the wording. I've sent 2 letters to do that.
which wording?
To change, I'm sure legal and Danielle know what those letters were.
So it might help to put in a little bit of perspective when we talk about these pools of monies and then what the legislation does and doesn't, because it will help our audience understand and it helps us as we think about where we need to go. So prior to the Racehorse Development Fund, which was set up under 23K, purse money came through the sources that were described, simulcasting premiums, ADWs. Those monies went to the licensee, and the licensee is the racetrack. And they were put into purse accounts, and then contracts were entered into between the licensee, the racetrack, and the horsemen, and they could determine how to use that purse money. And some of that purse money went to administrative expenses, I would imagine. When the Racehorse Development Fund came along, it took money from licensing, and then it'll have money from the slots parlors, and eventually money from the Category 1s, and it put it into this fund. It pretty much tracked the same type of language that was in 128A, so they divided it into 3 different buckets. When it says 80% goes to purses, that's true, but it gets paid to a licensee. And part of what we're thinking about now is who is the licensee on the thoroughbred side. So if we have a thoroughbred licensee, there can be Racehorse Development Fund paid to that licensee. The language goes on to talk about how that licensee will enter into contracts with the horsemen, and I would believe that they could make some decisions about how to use some of that money. But right now, we don't have a licensee that has a permanent kind of schedule. There's a percentage, 16%, that goes towards breeders, and that can be paid to an authorized breeders association, one that's approved by the commission. And then there's 4% that goes to what I call health and welfare. And that language is a little bit unclear in that it seems to suggest that it goes to a licensee, but the commission could look at that, and we could, think about how that may or may not happen. So I think part of it is we want to be responsive, but part of it is the language that we have in the legislation and, who does the money go to? And I think it's sort of the central question, who's the licensee on the thoroughbred side?
Mm-hmm. So I know I've read the letter with regard to let's just, if we can parcel this out, because I know this is important to Mr. Spadia and to the entire group. The 16% to breeders. There claims to be the one organization that's always But if we could verify that, I think what you're saying is you'd feel comfortable recommending to us that we could distribute those monies.
I
Is
think we
that-
could, I think we could. We could certainly consider doing that.
Okay. So, in order to verify, would we need, how would you suggest we verify that?
So, as I recall from past years, they've come before the commission, they've explained who they are, they've showed proof that their members have authorized them to represent them. The commission has approved them as the breeders' organization, and then I think that would be sufficient to release that money. And that works for both the harness and for the
Yes, I
thoroughbred.
do recall those approvals in the past. Are we prepared to do that quickly, Mr. Spadia?
Well, what happened, we have a placeholder's license. We requested to have it, as you know, we requested to have our license.
But that,
But
That
we
doesn't
have a,
We're talking about the 16% though.
I know the breeders will be speaking on that themselves, they're here. They will
Okay.
be asking for that.
Okay.
Those are two different organizations. Doesn't help me at all. We have a license and, we have a placeholder's license. We've had it right along. We've asked to change that license so that we could, I get
but there's
confused
no,
every day.
that placeholder was only to give you time to get us a full application, which demonstrates that you have a place to race, you have agreements in place, do you know what I'm saying? So that's,
Yes, I do.
it's not the recommendation that we're getting, that placeholder license allows us to treat you as the licensee. Now, especially now, when we're talking about Suffolk wanting to be the licensee and making agreements with all of you. Do you see what I'm saying?
If I understand the commission correctly and its counsel, with respect to the 80% money, the commission's, I think what you're hearing out of legal is that you don't have a licensee, therefore you can't act or do anything with that. With respect to the 16%, it goes to the breeders, and the breeders will speak for themselves.
Okay.
With respect to the 4%, I thought I heard something a little different from Attorney Blue, saying that that may be an issue of your discretion, and we would ask you to exercise that discretion to make that money available for the HPBA benefit programs.
Okay, so that narrows the issue. You chose your words carefully there. So what are you, it sounds like your sense is that this might be something that we would consider doing.
I think it's something we can consider. What we would like to do is look very closely at the language and then offer you some options to consider so that you could take action in a way the commission was comfortable.
That would be.
So could we be prepared to do that in 2 weeks?
Yes, we could.
Would that help you if we
That would
could?
help me tremendously, because then I can make sure that the medical benefit plans stay in effect.
Okay.
Well, so we can't commit as to what we will say on this 2 weeks, but we can commit to saying it. So you'll have a decision out of us barring something extraordinary.
And I promise you, we will shortly have an agreement, I'm hoping, with Suffolk Downs and be able to straighten the licensing situation out within the next few days.
Okay.
Okay. I thank you
We-
for bearing with me.
We'd love to be, I think you see, we'd like to be helpful, but we have to do it in a way that's legally sustainable, and I think this one particular area, we could probably act on quickly. And hopefully, if you get us more information, we'll act as quickly as we possibly can.
I appreciate that.
So I think we've covered all of the issues except for one, and that is the one that's addressed in a letter dated February 11, 2015, to Attorney Catherine Blue regarding comment on the HRC review of the Racehorse Development Fund for multiple licensees.
Hang on a sec. Yep. Oh, nope. Yep. It's in that package at the back. It's after.
It's at the back?
It's after
Okay.
the blue section. Now, flip this direction.
Okay.
No, I'm sorry. You in that February 11th series?
Yeah.
You'll get to it.
Okay.
Comment on HRC review.
This, we did all this.
Okay.
It's the third one, I think.
And what I would
All right.
simply like to call to the attention of the commission is that in the indented paragraph at the bottom of the page, we quoted the language of the statute. And it says that 80% of the thoroughbred funds approved by the commission are required to be deposited weekly into a separate interest-bearing purse account to be established by and for the benefit of the horsemen. So when the commission was addressing the issue of that 80%, and the issue was who is the licensee, what I would suggest is that under the statute, it says the money is to be paid to a purse account that the Horsemen's Group, us, the NAHPBA, establishes. So I am just simply suggesting that you ask council to take another look at this again, but it seems to me that the statutory requirement is that that 80% be paid into a purse fund, and once the HPBA has established a purse fund, which we will do shortly, that money ought to be paid to us, and that solves our money problems.
Okay.
We can take an additional look at that. We think the further language in the statute may make that a little bit different, but we can certainly look at that.
Okay.
So,
And that will be a subset of the bigger 80% issue, which is hopefully going to get resolved when you make your package deal here.
That's correct.
Right, okay. Just to reinforce the idea of, I think, the critical path chart of things you're going to need, whether it's legal or Dr. Lightbound or Mr. McDonald.
I've made a note to do that. We will
Okay,
do that.
that'd be really helpful for us to, if you want us to try to meet your schedule.
We appreciate the commission working with us and the effort it's made to accommodate the thoroughbred horsemen. And we note that we believe we have a common goal of furthering the interests of the industry and saving the jobs that would otherwise be lost at Suffolk Downs. And I applaud you and I thank you for your time and attention.
Our pleasure.
Thank you.
Pleasure. Mr. Tuttle, do you have anything you wanted to particularly add?
I don't. If the commission has any questions about our letter or anything based on what you've heard, I'm happy to answer.
I think I have a couple of questions, Mr. Tuttle. How are you, sir?
Good, nice to see you, Commissioners.
You too. I'm just trying to straighten out the information that we receive because it always doesn't flow in, and I know that part of that is because of the ongoing negotiations. So are you, I understand what your letter says, but are you confirming that you're close to a position where you would go back to the legislature to ask for an amendment, a racing amendment, and then follow that up with an application to us in which we could move forward to investigate?
Yeah, let me see if I can clarify that for your benefit and for everybody's. Because 128A and C were only extended for this quarter, these 3 months, there has to be some legislative action in order for things to continue for, the future, obviously, for the next, whether it's a year or 2 years or however long the legislature decides to renew the statutes for simulcasting and racing. We have worked very, very hard with the New England HBPA and are very sympathetic to the plight of the HBPA based on the unlikely circumstance that it would have money building up in this racehorse development fund, but perhaps not a place to race. So we have tried to accommodate its request to use our facility subject to economic terms that make sense for both organizations. What we are contemplating and what we are very close to, the conversations have been very productive for the last couple of weeks. What we are contemplating is an agreement whereby there would be 2 licensees, running horse licensees in Suffolk County. Our 2014 license, which has been extended into 2015 by the legislature, by the action they took at the end of the year, and the HBPA's one-day placeholder license, subject to your additional action, could continue as well. There's precedent for this in other parts of the country where multiple race meets are held at one location. So, for instance, for years at Santa Anita, the owners of Santa Anita Los Angeles Turf Club would have one race meet, and then a not-for-profit racing association, the Oak Tree Racing Association, would have a race meet as well. So what we could be able to accomplish is the ability for Suffolk Downs to continue to simulcast for the next 2 years as the horsemen develop their long-term plans for building their own track, and the horsemen would be able to conduct a race meeting at our facility during that time as well. And so we're very, very close, as they said. Whatever our agreement will require changes in the next round of legislation on 128A and 128C, and then presumably we'd be back in front of you after that to very quickly establish schedules and what the whole course of the next couple of years would look like.
So you wouldn't actually be the licensee just for simulcast?
I think there would be, we would be a running horse licensee by virtue of having this legislation extended. Okay, so the legislation that was enacted at the end of 2014 extended our license
To simulcast.
Yes, into 2015. Well, it really didn't. It extended our ability to simulcast, but what it extended was our 2014 running horse meeting license. That's
Well, but that's subject to an application to us that is approved, and we do not have that.
Yes, I think it's similar to the way we view it as similar to the way that the Wonderland and Raynham licenses are extended by legislation, and that the language that the language of the extension invited us to apply for dates. I see Attorney Blue nodding, which I take as a good sign.
Well, we read the language to say that the simulcasting was certainly extended. But if there were to be live racing, what it did was extend the date by which they could apply to the commission for live racing.
Correct.
Yes.
So that does imply that they could be a
But that's,
racing licensee.
Yes, they could apply for live racing. Yes.
Yes, and so we would, if we're able to finalize our agreement with the horsemen and they're able to conduct a meet at our facility, it would eliminate the need for us to apply for dates. And if we're not able to finish our agreement with the horsemen and we need to apply for dates in order to be eligible to simulcast, we're prepared to do so.
So we would need to look at, we'd have to see what the legislation looked like, because there are a lot of intricacies of 128A that would have to be addressed by the legislature.
okay. So I think the critical issue here is timing for all of us. And I know you're aware of that, and I know the horsemen are aware of that, and so we'll wait until we see what the legislation looks like, and then we'll have a legal review done and move forward.
Thank you very much.
Thank you.
All right, thank you. All right, we have a couple of representatives from Mass Breeders, Kevin Considine, George Brown. Welcome.
Good morning, Mr. Chairman, Commissioners.
Morning.
Morning.
Good afternoon.
Oh, I'm sorry, good afternoon. For the record, my name is Kevin Considine, and I represent the Massachusetts Thoroughbred Breeders Association, Inc. With me is Mr. George Brown, the chairman of the board. And we are here for a very simple request, that the commission release to the Thoroughbred Breeders Association $93,600. And I would like to respectfully refer the commission to the letter we submitted dated January 14th, which contained attached several sections of the applicable statutes, which demonstrate that by act of the legislature in 1991, this corporate entity was established as the recipient of funds for the breeders. They've been in continuous existence since that time. And the statute also provided that 8% of the monies received by the organization could be used for administrative expenses, promotion, advertising, and related expenses. And that is what we're focused on today. It's got nothing to do with races. It's got nothing to do with money that may be eligible under the Racehorse Development Fund to pay bonuses on stakes races or mass bred races. This is strictly that section of the statute that allocates 8% for administrative expenses.
You say 8% or 8%?
8.
8. Where's the 8?
The,
I thought you were talking about
the
this.
8 is contained in Chapter 114 of the Acts of 1991, which is Exhibit A to the letter that we submitted, and I think you'll find the language in the last paragraph of that statute. If I could draw your attention to page 232. Well, second to the last paragraph. The last paragraph concerned the annual audit. But the penultimate paragraph provides the Mass Thoroughbred Breeders Association, Inc. is hereby further authorized to expend up to 8% of the amount received each fiscal year for said program for advertising, marketing, promotion, and administration of the breeding program.
This is page 232.
Yeah, can you see it?
It's
Statute
Exhibit
attachment?
A to their letter.
Yeah.
And
this
it's
is-
on the very bottom, it's 232 of a statute, so it's in tiny
It's actually-
print on the
it's
bottom
closer to
of the
the
letter.
top
Oh, all right, section 4.
paragraph.
Okay. I see, okay. Yeah, got it.
And what I'd like to point out to the commission, because listening to today's events, there seems to be some confusion between the role of the breeders' organization and that of the horsemen's organization. And the breeders' organization really has two branches. One is to promote and develop the breeding of thoroughbred horses in Massachusetts, which is an ongoing process, which has nothing to do, quite frankly, with whether races are held here. And the second aspect of the program is to award bonus money to races that do occur here. But the existence of these farms, the existence of the breeding program goes on notwithstanding whether there's any actual racing. The number of $93,600 is my math. Of course, it would be subject to being checked by the commission and the staff. But when one looks at Section 60 and the percentage of money that was supposed to go to breeding and just applies the 8% for administrative expenses, that's the number that I came up with.
And that's 8% of which, of what bucket?
That's 8% of everything that the Breeders Association is entitled to by the statutes.
From simulcast, from whatever?
Well, actually, you're asking, that's a good question. So the Breeders Program over the years has been funded by a percentage of the handle. But what we're looking for here is just the percentage they're entitled to under the Racehorse Development Fund.
Okay, so it is, I thought you said it isn't about the Racehorse Development Fund, but it is.
It is, yes, it is. I'm sorry.
Okay, so is this 8% of the 16? One half of the 16?
Well, it's 8% of the 16%, which is not necessarily half of the 16. It's a percentage of that number.
Of the 16?
Of the
Okay, so it's,
16%, yes.
so it's 16 of, it's 8 of 16 of 75.
Yes,
Yes.
that's right.
Right.
Exactly.
Okay.
Yep.
I've spoke to you briefly about this yesterday, but you have had a chance to take a look at this and conduct an analysis.
So we traced through all of the sections of the statute that pertain to racing. We believe that they've all been extended in the other, in the legislation that extended everything for 2 more years. numbers aside, which we would work with CFAO Lennon on, it would make sense that they get their 16%, and then this statute allows them to use up to 8% of that for marketing and other purposes.
And I know this is, we spoke about this earlier, some kind of a verification that this is the,
We would want to approve the group. The commission would want verification they represent the breeders, and the
Yes.
commission would approve them, and
But we've done that in the past, right?
And you have
That's-
done that
that's
in the past,
been
yes.
routine, right.
yes.
Right. All right, so it seems like, subject to a couple of administrative matters, which is evidence to satisfaction of our council, that you are who you say you are and have been, and that the arithmetic gets worked out right.
Yes,
that
correct.
We would be prepared in a fairly non-controversial way, so we'd be comfortable doing it with the three of us, to authorize this expenditure. Does that
I
seem
think
right?
that's right, yes.
Commissioners, that, just out of curiosity, so is it 8 of the 16, or is it half of the 16? Because it's 8. Is the language?
No, it's 8 of the 16.
8%
so
of the
it wouldn't be
16%.
half. It's not 8 of the
Yeah.
total.
Of the
Right.
75.
Yeah, it's
Okay.
8 of the 16.
Okay.
Just for clarification, the letter you sent us back on the 14th asked for 1.1 million in change?
Yeah.
Okay.
So,
So this is a refinement of that request to the
Uh,
93,600?
yes, what the 1.170, well, $1,170,000 represents is what the Breeders Association would be entitled to if it were paying bonuses on purses. That would also include the 8% that represents the administrative fees, but because there's no racing, and there are no bonuses being paid on mass-bred races,
So
there's...
that's the 16%. The 16% is the million
Yeah,
one.
yes.
And 93,000 is more or less 8% of a million one.
Yes.
Okay. Right. Okay, that, clear?
Yep.
All right, do we have a discussion on this? Horse Racing Commissioner Cameron?
well, did you have a comment
No.
before we?
No.
So I move that we authorize the Thoroughbred Breeders Association to, well, I authorize that we
Authorize the general counsel to
authorize the
include-
general counsel to work with the Thoroughbred Breeders Association in order to facilitate the 8% percentage for the breeders to use as directed, and that's out of the 16%, 8% of the 16%. Obviously, these numbers would have to be verified through our legal staff and agreed upon.
And I would just suggest, if we're doing this, we do this now for both groups of breeders. We have two groups
Right.
of breeders. They are both covered by the same type of language. So if we could just have them provide to me, the general counsel, the materials so that we can get them approved by the commission, we can work on the numbers, I think that would be helpful.
So let me amend that. So I move that we authorize both breeders' organization to work with our general counsel in order to verify numbers and distribute the 8%.
As
just
discussed.
As discussed.
All right. Second?
Second.
Any further discussion? All in favor?
Aye.
Aye.
Opposed? The ayes have it unanimously.
Well, thank you.
All right,
Thank you.
Thank
Okay.
you.
good. All right. Have any other speakers come who were not on the sign-up sheet? Then I think we are concluded with this item. Is that right?
Yes, we are. That's
All
correct.
right. We are concluded with item 4. It is now, what time? 12:30. These other matters are pretty brief, right? So why don't we, let's take a quick break, and then we'll come back and finish our business and not take a lunch break. We will be back shortly. Okay, we are ready to reconvene public meeting number 145. We had some confusion about the sign-up sheets. We do have two more speakers on the prior topic who will introduce themselves, since I don't have the proper information. We also have had a request for everybody using the mics, the commissioners, to speak up a little bit, put the mics close to your mouth so that everybody can hear. So why don't you gentlemen introduce yourselves, and you're invited to speak. You first, sir.
Chairman Crosby, members of the commission, I'm Paul C. Brooker, National Director of the Horseshoers Union and Allied Equine Trades, Local 947 SEU. My concern today is the inactivity of racing has caused a lot of problems and a lot of worries. Families are worried about their finances, their home, and their social life. It has also caused the demise of many venues. We've lost the eighth pole, which is a great social and economical help to racetrackers. I'm an old Marine sergeant. I'm used to representing, speaking up for my troops. The buzzword today in business and politics is transparency. And until today, I have received no information or insight on the procedures of what is happening, especially at Suffolk Downs, which was my main concern. The only solid information I have received is from Mr. George Carney, who definitely does want racing at Brockton. And he's a great person to work for. I worked at Suffolk Downs for 43 years. I have no great complaints about it. But we need to know what is happening. I do not have the privy of closed-door meetings. I don't know what is happening. I cannot relay these information to my people. I have 4 horseshoes left up here in this area containing myself. My other horseshoes are spread out across the nation, and they don't know if they're going to come back because they don't know, because I can't tell them what is ongoing. I'm not saying it's you, but the main concern, which definitely is a priority, is the casino issue. Racing is the red-headed stepchild. Let's face it, that's the truth. But it's been here forever and ever. Lotteries killed racing. For every increase in lottery money, you saw a corresponding decrease in racing. And this goes back from when I came here from New York in 1971. You're not going to kill the lottery, it's there. But racing needs to continue. The demise of the eighth pole, the demise of some farms, breeders, ancillary services to racing is on the way out unless it's reconstructed. And it's got to be reconstructed in a reasonable frame of time and for an extended racing date. When I came up here in 1971, my job in the paddocks, I made $56,000 a year just in the paddocks, not what I made on my own. My W-2 form for this year was $12,500. Now, I'm fortunate that I have my Social Security. I'm 79 years old. I have my VA disability, and I have rental income. The majority of the people on the racetracks do not have this. You're costing the state a lot of money in unemployment. And taxes that these people would generate by their spending is no longer there. This thing needs to be expedited to let us know we're either dead, we'll bury you, or we're going to go on and continue in having live, profitable racing. It can be done, and I wish you gentlemen would look definitely, and you too, young lady, into it.
Mr. Brooker, I believe I saw you here at the beginning of the hearing today, correct?
That's correct.
So you heard all of our speakers previously?
That's what I said. I received more information and insight
Okay,
today.
great, because you know as much as we do right now then.
Yeah. And that is the undecided is definitely undecided.
Okay.
You know, I know I speak for all the commissioners, and there are real people behind these problems. We understand that.
Definitely,
you know,
yes.
and you know, this talking about money is not just an abstract concept. There are people who can't pay their bills, who don't know whether they're going to have certain kinds of insurance, whose pensions are at risk, whose jobs and income. We fully appreciate that, and we're trying to approach this as expeditiously as we possibly can, understanding that there are real people out here. Most of the stuff you talk about, as Commissioner Cameron said, is not within our control. Whether the industry and the tracks can figure out a way to put together an economically viable deal. If you've been at Suffolk Downs for 46 years, you know those folks better than we do. But we're certainly doing everything we can to try, to move the process where we do have a role as fast as we can, and to encourage the parties to move and to be as transparent as they can. But they've got business negotiations going on. You can understand what the issues are. But we're certainly doing our best to accommodate what you're
I understand that, and I realize you people have people to answer to, just as I do. And that's not always an easy task because, as you well know, if you get 100 people together, you get 99 opinions.
Right.
And 98 of them are wrong. Yours is right.
Absolutely.
All right, thank you very much.
Thank you, Mr. Brooker.
Thank you for coming.
Billy?
Thank you, Paul.
Yeah, William Ligorio, a longtime trainer at Suffolk Downs, 30-plus years resident of Revere, and I have read everything, and I'm hoping and praying that Suffolk Downs and our group can come to terms, and I've understood everything that was said today. I just want to say that from a horseman's standpoint, standard bred or thoroughbred, we're all brothers in horse racing, and I'd like the standard bred people to understand that they need to support us as much as they can. I certainly thank and wish them well when the commissioners awarded the license to Plainridge. And I thought that was a great step in the standard bred industry, and it saved an industry. Our industry is on the cusp, and the important thing here, and President Spadier of the HPBA said it, and time is of the essence, and I wish that we had a deal already in place. The essential thing to us is that any interruption in racing, for example, if we don't get something done and we have an interruption for a year or so, we probably will lose the core of our New England people. So that when, and in principle, 23K made a provision to escrow some of that money, it's possible that if we resurrect this in 2 years, that money will go to New Jersey folks coming up, New York, Maryland, et cetera, et cetera. So we'll lose our core values, all our people who've sat it out, and we've really sat it out and waited a long, long time. I had the benefits. I plowed for Mass DOT, so I've had a great year. But I know many of my fellow horsemen are down south, and right now they're on seaweed and cold water rations because it's very difficult down there to compete. Our core is here, our values are here, and I know the commission's worked hard. When the license was awarded to Wynn Resorts, I wish them luck. I might be the first one over there on opening day to see what goes on. But I also heard the commission say that they would do anything and everything, and you guys had a special meeting in order to preserve racing, thoroughbred racing in Massachusetts. And I only ask that if, in fact, we can, in principle, get a deal done with Suffolk Downs, we can work out the logistics to keep it going, because that money for us to keep racing going for 2 years, even if it is 50 days, which for me is very difficult. The horsemen will have a difficult time with 50 days. The thing that helps us is the horse population is down. Everybody will have an opportunity to make money, but it simply lies in we need to race this year. If we lose that, we'll lose some of the breeding farms. I have a mare in Florida that's going to fold there just by design, but I wish I had her up here. I have money invested in another racehorse, and I have clients. I have 2 doctors I train for, and they're looking forward to coming back, and it does infuse a lot of money into the local economy. So I would just ask that the commission continues the work they're doing. Commissioner Cameron has done great work on the racing side, and Commissioner Crosby and Stimmons all have done great work, but we need you now, more than ever, to help us to keep this going. And I know we need a deal done there, but if we can get that done, I implore you to expedite things as soon as you can so that we can, in fact, get a meet together, and that will save our industry. And I thank you for your time, and I thank you for all your help.
Thank you, sir. Appreciate it.
Thank you both very much. Okay, item number 5, Racing Division. You may have thought we just did racing, but Alex Lightbottom.
Good afternoon, Chairman Crosby and Commissioners.
Good afternoon, Doctor.
In your packet, you have a review of the Furosemide program that we began in 2014. This was an effort to comply with the model rules with RCI on their third-party LASIX administration program, but also to realize the local considerations. After we did this review, I'll go back. I'm not sure if you know what furosemide is. It's the only medication that's allowed on race day, and it's used to treat exercise-induced pulmonary hemorrhage, which is bleeding from the lungs in thoroughbreds. And this program that we instituted was to kind of tighten the controls on this. So Sergeant Babin, after doing the review, came up with several recommendations. One of them was comprehensive training for all involved, our commissioned personnel, the trainers, stewards, etc. Also to have our employees sign a document saying that they understand the program, strict adherence to the program, including disciplinary action if it's not adhered to, and a monthly review by the Director of Racing or her designee. In addition to that, I recommend that we review and update the standard operating procedures that we developed and have a meeting with our MGC legal staff and the judges and stewards to go over enforcement issues. Additionally, we're planning on forming a working group to look at the furosemide issue with input from the stakeholders and see if we can further develop this program. Do you have any questions?
I'm very familiar with this issue. I'm happy to see that there was no fraud or misconduct with these violations. The investigation revealed no fraud or misconduct. I agree with the recommendations that training is an integral part of moving forward in a consistent manner, both tracks, same message, everyone trained by the guidelines. The working group, also an excellent idea, because I know that there is, some states will allow a little leeway, other jurisdictions will not, so I think the working group with all the stakeholders to really determine what is best here in the Commonwealth, and then the training, sign for the fact that you've received the training, you understand the guidelines, and then discipline if there are violations after that. So I think the recommendations are sound. I thank you for taking the lead on this. Director Day putting the working group together is an excellent idea, and I think this will give clear direction to everyone moving forward.
Thank you.
I mean, first of all, I'm probably now better educated on this drug than I had any anticipation when I started reading the memo. But I want to get down to the end of it where you talk about adopting some policies and changes in advance of the start of the harness racing season. Can you just kind of give me a timeline for, you talk about maybe having some recommendations. Do you
Yes,
see those coming back to us before Plainridge starts their season?
Yeah, what we'll do with the working group is discuss these issues, explore in further depth what some of the other jurisdictions do as far as leeway. We may decide that leeway is not a good way to go. I don't know where the group will end up. Also, the group may not come to a consensus. But we thought it would be a good idea at this point to involve everyone and explore the issue further. And then once that's done, we'll come back with a report. And if there are any specific recommendations everyone can agree on, we'll bring those forward.
So will this group take Sergeant Babin's suggestions too and decide whether or not to incorporate them, or have you already incorporated that?
I think today we're asking to go ahead and approve those.
You are,
Sergeant
okay.
Babin's, and then the two at the end as far as mine with the standard operating procedure update and having a meeting with legal. And then what we'll do is we'll see what develops from the working group, and if there's something that we can bring forward from that, we'll bring that also separately.
Okay. All right, so the working group is going to be looking at the timing issue, you know,
Yes.
how strict you want to be and whatever other issues come up.
Mhm.
Is the working group also doing the review and update of SOP and the,
I'll be working on the SOP,
Yeah.
and certainly if we decide to go with something a little bit different from what we did last year, that would need to be incorporated. So
Okay.
that'll be updated after the working group. The finishing touches actually would be put on after that.
Speak up.
Thought I had it right there. That means we would essentially take any suggestions we get from the working group, those we want to move forward would be incorporated into our policies and procedures, and then we'd be retraining accordingly.
Right.
And we would, the plan would be is to move forward with the recommendations that are outlined here. We're letting the commissioners know that this is the direction we wanted to go, and then ask if you have any different directions or suggestions. Otherwise, we'll proceed as we've outlined.
Now, I think the plan is sound, and I also want to commend the Racing Division for recognizing an issue, working collaboratively with legal and IEB to investigate the matter and come up with recommendations, the working group being one of those recommendations. So I think it's a sound way to move forward.
So I don't think you need us to vote on these.
No.
Right.
This was just a briefing.
Yeah. Great.
Great
Thank you.
job.
Thank you very much.
Thank you.
Thank you.
Doug, that brings up unclaimed wagers.
Yep.
Yes. Good afternoon, Mr. Chairman and Commissioners.
Good afternoon.
I want to discuss the unclaimed wagers from 2013. You have letters in your packet pertaining to the winnings on wagers from the different licensees, the racing and simulcasting facilities, specifically Suffolk Downs, Plainridge Race Course, Wonderland, and Raynham Taunton. In accordance with the general laws of Massachusetts, Chapter 128A, Section 5, unclaimed winnings on wagers are payable to the Commonwealth within 90 days of 12/31 of the year following in which the wager was made. So again, this will be for the unclaimed tickets for 2013. We've reviewed the outstanding ticket account, better known as the outs books, which was provided by the tote companies. And we have determined the following monies owed to the commission from the unclaimed tickets. Suffolk Downs is $293,054.65. Plainridge Race Course is $138,036.61. Wonderland is $19,080.81. And Raynham Taunton is $157,119.84. The letters in the packet will be distributed and sent to the tracks with your approval. Once that is done and the monies are received from the commission, we then send out a memorandum regarding where the monies are dispersed. And for Suffolk Downs and Plainridge, under Chapter 139, Section 10 and 20, they are distributed back to the purse accounts. And the payments regarding Wonderland and Raynham will go to the Racing Stabilization Fund, which is pursuant to Chapter 86 of the Acts of 2010, Section 14. And this is done in a fairly reasonable time frame once we do receive the monies from the tracks.
This is in keeping with how we've been
Yes.
handling this matter for years. Is there any difference here because of the uncertainty with racing at Suffolk Downs?
This money, from what I understand, is earmarked for 2013.
I see. So that's, right, that's money they're due. Okay.
Do I read this correctly, that the payments from Sterling Suffolk and from Plainridge, we will receive, we will then immediately turn it around and send it back to them to go into their purse accounts?
Yes, once we receive the money, once the letters are sent out to the respective tracks, Plainridge and Suffolk Downs, those monies that we receive from the unclaimed tickets prior to, we have to receive them by 4/1 or before. Once the money has cleared, we will then distribute that money to the purse accounts for those two establishments. Now, regarding the other two, Raynham and Taunton, those monies are earmarked for the Racing Stabilization Fund.
Right,
Because they didn't-
I'm only talking about it just seems a little weird. Why do they have to send us the money, then we send it back to them?
It's an accounting all the numbers are verified, all the money's collected. We're verifying that the monies that the totes supply, that the numbers are correct. It's all accounted for, logged properly,
Right.
and then resubmitted. So it really is more of an accounting practice. And
It's in the statute, and that's the way it's
Yeah.
been done.
Okay. Who am I to question the way it's been done? Yeah. Okay.
So we need,
Seems straightforward.
we need your approval on the letters, to send the letters out.
Okay.
By vote?
So I'll move that the 2013 unclaimed tickets from horse races, unclaimed tickets from dog tracks, the recovery of unclaimed winnings, at all of the tracks, and, at each of the tracks, I move that we authorize
the
the
letter.
racing division staff to,
For the letters as written.
to collect the monies and send them back as appropriate, as the statute reads.
We need the approval to send the letters out now. Once we receive the monies and have them in-house, we will need your approval to
Right.
disperse those monies.
So we're authorizing
The letters.
Just for
the
letters to
letters
go out.
at this point to go out, the monies to come in, and authorize also to go back, the appropriate distributions back to the tracks.
Correct.
Second?
Second.
All in favor? Aye.
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 Opposed? All right. Go
We
for
like
it.
to keep things simple in racing.
Yeah, I see that, right. Thank you.
Thank you.
Thank you.
I think that's it. Is there anything else?
Nothing here.
Executive Director
No,
Day?
that's it.
Any commissioners?
No.
We have a
Move to
motion to adjourn? Second?
Motion, second.
All in favor?
Aye.
Aye.
We are adjourned. Thank you.